Can states legally and successfully shut off water to a federal agency? Absolutely. It's already been done. Yucca Mountain is in Nevada, about 90 miles northwest of Las Vegas. It was originally selected as a nuclear waste dump in 1987, but it wasn't until 2002 that President Bush and Congress officially approved the site and moved to make the dump a reality. This was not a popular move in Nevada. The governor filed an official notice of disapproval of the site selection, but the federal government rejected it. Nevada filed several lawsuits disputing the EPA's standards for the site and asserting the Nuclear Regulatory Commission's duty to uphold public health and safety standards. To run the drill rigs necessary to take soil samples, as well as other operations, the feds needed to pump more than 140 million gallons of water to the area each year. But state law governs the use of groundwater, not federal law. In 2002, the U.S. Department of Energy filed applications for permanent water permits with the Nevada Division of Water Resources. But the state engineer rejected the applications on the basis it was detrimental to the public interest and that the state legislature had previously determined it was unlawful to store waste at Yucca Mountain. Nevada still allowed federal officials to use a limited amount of water at the site for showers, restrooms, and fire emergencies. Eventually, the DOE began ignoring the restrictions and started drilling operations anyway. In the summer of 2007, state engineer Tracy Taylor issued a cease and desist order blocking further water use for drilling. The feds filed an emergency injunction challenging the order based on the supremacy clause of the Constitution. The DOE motion asserted that the state wasn't just protecting its water rights, but trying to block a federal project. Surprisingly, the federal court sided with Nevada. In his 2007 opinion, the U.S. District Judge wrote, "The validity of Western states' groundwater rights and the right to regulate water in the public interest is not a right to be taken lightly, nor is it a right that can cavalierly be ignored or violated by a federal agency." Regarding the Supremacy Clause argument, he wrote, "At present, the only public interest issue is whether state officials can be precluded from exercising their lawfully mandated duties, or whether a federal agency can run roughshod over a state's rights or interest without specific authority and mandate to do the precise activities it wishes to do." The department appealed the decision, but due to the long-standing roadblocks, the feds announced plans to kill the project in 2010. As a result, the DOE withdrew its water application, effectively ending the lawsuit. While there have been efforts to revive the project, today it remains effectively dead. Even if Congress does resume efforts to build, the feds will still have to find a way to get water. Refusing to provide water to a federal agency worked. The feds didn't just march up the mountain and take the water, and trucking it in was both cost prohibitive and almost logistically impossible. Even a federal court upheld the right to refuse cooperation under the anti-commandeering doctrine, and the state action ultimately forced the federal government to scrap its plan.